Andarki Shubhodayam. Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. Professional Ethics class. Dear friends, in the legal ethics, I told you that the advocate, no doubt, he can represent the client, and at the same time, he should not become the mouthpiece of the client. That means, whatever the client says, you have to tell the court which is legal, which is not legal, which has to be projected before the court and which you should not. This is what you have to know. And likewise, in the case of Prahlad Sharan Gupta, P.S. Gupta versus versus Bar Council of India, I told you that you cannot give any undertaking without the lawyer's consent, without the explicit authority of the client. And while speaking with the opposite party also, you must be very, very careful. You should speak to him only in front of the opposite lawyer. Here, Honorable Supreme Court of India, two judges bench, Justice Pankaj Mittal and Sanjay Karol. In the case of Srimati Lavanya, she is an advocate, versus Vithalbgurdass Pass, and she already died, represented through legal LRs, civil appeal number 13,999 by 2024. On 5/3/2025, the bench held that the lawyer should not give any undertaking to the court without the explicit consent, without the explicit authority given by the plaintiff. Suppose if the court says, no, this property should not be disposed till the next adjournment, can you give assurance? Yes. After contacting your plaintiff, then you have to say. Otherwise, you cannot say like that, and don't commit on paper. If you commit on paper, the problem will come. Now let us discuss the case. Vithalbgurdass and others, they filed OS number 491 by 2007. Yenduku, to revoke or cancel the joint development agreement deed dated 30/4/2004. This is in connection with the construction of certain residential plots. The time limit is 24 months, that too on turnkey basis. So 2 years means 2004 agreement, and it should be completed by a certain date, 31/10/2006. But it could not be done. It's become a failure. So therefore, they wanted to rescind or revoke from the so-called joint development agreement. While the matter is going on, the plaintiffs came to know that the defendants, that is Vithalbgurdass and others, they are disposing. Vithalbgurdass and others, they came to know that the other party is disposing the flats or semi-constructed flats to some other persons, prospective buyers. When the matter is pending, they should not have done it. So therefore, they have asked for the injunction order and things like that. And at that time, Srimati Lavanya, advocate, representing the party. So when the court stated that you should not sell to any third party, and she said yes, and she agreed, saying that nothing of that sort will be done. Fine, but later the court came to know that some other plots were disposed by these parties, that is violation of the undertaking given by the lawyer. Now they want to take it as contempt, because lawyer, you can take under contempt of Courts Act 1971. If there is any willful disobedience on the part of any person in implementing the orders of the court, they can take it as contempt. But here, who has done? The client. of the advocate has done. So how can you, is it is so no doubt we all tell you that the relationship between the lawyer and the client is fiduciary, but for the act done by the client, lawyer should not be lugged in, should not be put into trouble. But here, since he has given the undertaking, the problem has come. So what I advise you is, please remember, do not give any undertaking without explicit authority, just like in P.S. Ramurthy case. Yes, he has given undertaking, and ultimately this advocate has taken money or appropriated money from the JDR, did not pay to GHR. When DHR moved around him, once again he has deposited the money in the court. For getting the same from the court, he has the client has to spend about 250 rupees, like that. So don't do such things. No doubt you can consult the so-called client. You can express the legal position, then you have to tell correctly. But unnecessarily do not give undertaking. Likewise, another point I want to tell you, do not become a surety for any client. The relationship will definitely become so. So these ethics, these rules are definitely, they will increase your professional experience. So ethics are very, very important. So I am here stopping. Thank you.